Good morning, everyone. As you know, this is the Court of Appeals, and we are one court, even though we sit in different sections. And today, we're lucky enough to have Judge Valerie Smith from the Western Section sitting with us. And she will, I'm sure, bring a great deal of wisdom to these proceedings. Another thing to mention is that these arguments are streamed live on the internet, in case you didn't know that. That means whatever you say goes out there, and it can't be retrieved. So always think before you talk, and be careful with what you say. For the appellants, when you come up and introduce yourself, please let us know if you wish to reserve any time. You can reserve up to 5 minutes. Are there any announcements or anything else? No? Seeing none, would you call the first case, please?
Pamela, Salas, 1 John, David Rosdeutscher, MD, et al.
You can move it.
Oops. Good morning, Your Honors. May it please the Court. My name is Matt Klein. I'm here on behalf of the defendants' appellants. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes, okay.
Thank you. So the issue, and I know the Court has read the briefing, but I want to just briefly summarize the issues that we're dealing with. The first question is, when did the saving statute begin to run? Did it begin to run on the date of the order granting the voluntary dismissal, or did it begin to run on the date of the judgment awarding sanctions? Our position is that the motion to dismiss should have been granted regardless of which date the court ultimately chooses. The second issue is, if the latter date applies, did the trial court abuse its discretion in finding that extraordinary cause excused the plaintiff's failure to comply with the pre-suit notice statute under the Healthcare Liability Act? So beginning with the first question, the threshold question of when did the saving statute begin to run, it is our position that the general rule under the case law and Rule 41 is that the saving statute begins to run on the date of the order of voluntary dismissal. Now, there are some exceptions to that rule that have been defined throughout the case law. One of those is that if the order of voluntary dismissal is modified within 30 days, pursuant to Rule 59, the date of the modified order of dismissal would govern. That's the Edwards versus Banco Lumber case. Another exception is that if the order of voluntary dismissal, or I shouldn't say voluntary dismissal, if the order of dismissal is appealed, then the date of the final resolution of the appeal would apply. That's the Parrish case and arguably the Romanov case, which the trial court relied on from the federal district court. Neither of those exceptions applies in this case. There was no modification of the order of dismissal within 30 days under Rule 59, and there was no appeal of the order of dismissal. The plaintiff in this case was not a party to the appeal of the sanctions order that eventually occurred. The plaintiff's position, and that generally adopted by the trial court, is that there must be finality of the order of dismissal in order for the saving statute to begin to run. No Tennessee appellate court has said that. And it is our view that that would lead to absurd results and indeed would be contrary to the Frazier case from the Tennessee Supreme Court. And there are a couple of examples of this absurd result. So if you have a case with multiple defendants and a single defendant is dismissed, under the finality argument, that saving statute doesn't begin to run on that single defendant until the case has been fully and finally resolved as to the remaining defendants. That could be years later, which obviously runs counter to the purpose of the saving statute, which is to provide a brief period of time within which a plaintiff can refile a case.
What's the distinction you would draw between, and you accept essentially under Parrish, right, that if there's an appeal, that's a different circumstance, and that's your reading of Romanoff, that it's an appeal circumstance. What's the difference in terms of why the date would start differently for an appeal than it would for a non-final order? And why draw a distinction between those two? You are drawing a distinction, but why?
I do draw a distinction, and if I understand the court's question, it is that if there is an appeal, but there's no appeal of the order of dismissal.
Right.
Well, I think that this case is the perfect example of that it would lead to absurd results. We have a sanctions order that's entered against plaintiff's counsel, which is essentially a third-party claim that we had against plaintiff's counsel, that then goes up on appeal. Well, that went up on appeal. It was affirmed in part and vacated in part, went back down to the trial court. The trial court reaffirmed sanctions, actually entered more monetary sanctions. There's now a new appeal pending. And it's been 5.5 years since the order of voluntary dismissal was entered. And so that's the argument about why we submit that there must be a distinction drawn between an appeal that addresses the order of dismissal and an appeal that has nothing to do with the order of dismissal. It's that you end up with this scenario that we have in this case. And I think that, turning back to my point, the Frazier case, I think, is really instructive. It is a case involving a single defendant from the Supreme Court. It is a case involving two defendants. It's a doctor and a hospital. I believe it's the hospital is voluntarily dismissed, and then about a year later, the plaintiff amends the complaint to add the hospital back to the case. And so the issue the Supreme Court was confronted with was, when does the saving statute begin to run for that single defendant? And the court in that case said it's the date of the order of voluntary dismissal. There's no finality requirement, and that's the rule that we're advocating that the court recognize and follow in this case. Turning now, unless the court has more questions about the date on the saving statute, I'll turn to the extraordinary cause issue. So it is our position that the trial court originally selected the first date, altered or amended its order, and changed it to select the second date, which is the date of the sanctions order against plaintiff's counsel in Salas 1. And it is our position, and then the trial court then found that the plaintiff did not comply with the pre-suit notice statute, which we contend was correct, and on appeal, the plaintiff hasn't really disputed that the pre-suit notice was not properly sent under the Child's case, which says you can't send pre-suit notice for a refiled case while the original case is still pending. That notice is meaningless, it is ineffective. And so under the Child's case—
I want to ask you a question about that. So
Sure.
This is some language from Child's. In light of our disposition of this issue, the question of whether a plaintiff in a medical malpractice action may satisfy Section 29, 26, 121 for the purpose of notifying the defendant of a potential refiled action by sending the requisite information to defendants during the pendency of the first action must wait for another day.
Yeah.
Did Child's really decide what, and both parties seem to be suggesting Child's decided?
Yeah, and I think the trial court also felt that Child's decided the issue. I noticed that language yesterday. It is an inconsistency within the text of the Child's opinion, because clearly in the preceding section of the opinion, the Court of Appeals adjudicates that issue. They say that this notice is meaningless, it is ineffective, and then it moves to the issue of extraordinary cause. And that sentence that you have just quoted is from the section on extraordinary cause. So that's an internal inconsistency in the Child's decision. Because if you read the earlier part of the decision, they absolutely adjudicate that issue. They say that a notice letter that is sent while an original case is pending is ineffective, it's meaningless. And so I'm not exactly sure how to reconcile that other than to note that it is an inconsistency. And if you read the opinion as a whole, it is clear that they have adjudicated that issue.
Let me ask you about another
Sure.
potential inconsistency here. So if the trial court's right in terms of the timing issue, pre-suit notice doesn't have to have been submitted yet, does it? I mean, there's still a live controversy in terms of this action, at least as of the time of filing of this appeal, isn't there?
Yeah, there's an argument that there's prior suit pending still, which I think lends credence to our argument that interpreting the saving statute in that way would lead to an absurd result, which obviously is against that canon of statutory construction. But I take the court's meaning. I mean, I think the broader point is there's no claim pending for the plaintiff against the defendants in Salas 1. And so that's why we think the decision to utilize the latter date doesn't make sense, and that requiring finality also leads to absurd results and doesn't make sense. As to the extraordinary cause, so Child says that notice cannot be sent while the original case is still pending, which is effectively what the trial court concluded and what the plaintiff has not contested on appeal. And then the analysis becomes, okay, should the trial court have excused that based on a finding of extraordinary cause under the pre-suit notice statute? And we submit that the trial court erred in a couple of different ways in doing so. First, the trial court applied an incorrect legal standard. The Myers case from the Supreme Court defined the extraordinary cause standard. Now, the trial court cites Myers and discusses some aspects of Myers in its order, but the trial court never mentions the extraordinary cause standard, which Myers is the seminal case from the Supreme Court recognizing that this is a high bar. Instead, the trial court applies the Howell and the Hinkle cases, which were decided before Myers, and Howell indeed was expressly overruled by Myers. The Myers court says in a footnote, to the extent this decision is inconsistent with Howell, we overrule it. Well, we submit that Myers is absolutely inconsistent with Howell. And obviously Howell involved a unique procedural circumstance because the case was filed just a few days after the pre-suit notice statute went into effect. So it was a unique procedural circumstance that is obviously not present in this case. So we submit that the trial court erred in applying an incorrect legal standard in that way. And also, the trial court relied on, and I go back and forth about whether this is a factual finding or a legal standard, but the trial court, two of the bases for the trial court's decision in finding there was extraordinary cause was that pre-suit notice was sent, even though it was ineffective, it was sent, and that a certificate of good faith was filed. Well, the Stevens case from the Tennessee Supreme Court rejected those as a basis for finding of extraordinary cause. And so we submit that the trial court erred in relying on those two facts as well. And then finally, and the reason we submit that that was error is because whether notice was sent or received or whether a certificate of good faith was filed is irrelevant to whether the cause of the defective pre-suit notice was extraordinary, which is obviously where the inquiry focuses based on the subsequent case law. Moxley provides a great discussion of extraordinary cause. And that leads to my second point. The trial court essentially based its ruling on extraordinary cause on its determination that there were procedural ambiguities in Salas 1. And we argued through multiple rounds of briefing in the trial court that there needs to be evidence from the plaintiff via an affidavit, as there was in Moxley, as there was in Hunter, to explain it was this procedural ambiguity that led to my failure to comply with the pre-suit notice statute. There was no evidence. And in fact, if you look at Moxley and Hunter, they get into the details about, okay, here's the excuse that's given. Is it actually linked to the reason pre-suit notice wasn't properly sent? That link has never been provided in this case. There's never been an affidavit explaining how these procedural ambiguities led to this issue. And even in the briefing, there is, putting aside whether there needs to be evidence, the briefing doesn't link that. The trial court essentially makes some assumptions about how these procedural ambiguities could have led to this issue, but the briefing doesn't tie the knot. And we would submit that this is a case involving attorney oversight or a misunderstanding of the law, which multiple appellate cases have said do not rise to the level of extraordinary cause absent extraordinary circumstances. So we would ask the trial court reverse the order of dismissal. Thank you.
Thank you very much.
Good morning, Your Honors, and may it please the Court. My name is John Spraggins, and I represent the appellee, Pamela Salas, the plaintiff in the underlying action, whose alleged and developed evidence over the past 7.5 years that she was a victim of medical negligence and has simply been trying to get to a trial on the merits of these claims. And this is not the usual situation that's very common under the Tennessee Healthcare Liability Act, in which there are traps for the unwary and a plaintiff falls into those traps. This is about an extremely unusual pair of orders that were issued by the former trial judge in this action, 13 months apart, that has produced this situation in which the appellants, the defendants below, are taking a position of heads I win, tails you lose. Their argument is essentially that she filed her pre-suit notice for her second case too early because the prior case was still pending. But she filed the second case too late because the case was already over. And this is a Schrodinger's cat situation in which it can't be two things at the same time. Particularly in light of Tennessee's well-established public policy that cases should be resolved on their merits and not procedural complexities or hurdles, and that the saving statute should be applied to get cases to their merits. So I'd like to address the two orders that are really at issue here. First, the March 26, 2020 order in which Judge Kelvin Jones entered the order of voluntary non-suit, but expressly found and wrote in the order, quote, "This is not a final order." And he cited to the Mensch versus White Eagle Property Group case. The relevant passage essentially describes the well-settled principle that a judgment is not final where it does not adjudicate a prejudgment request for attorney's fees. Well, what was still pending in front of the trial court after that order came down? It wasn't just sanctions in the form of a monetary payment by her counsel in the trial court. It was actually a request to dismiss the case with prejudice. That remained pending in the trial court up until the date of that order in April 2021.
Wasn't the request under Rule 37 as well?
Yes, but it would have impacted the entire case. I mean, this was a request to dismiss this plaintiff's case with prejudice.
But it was part of the sanctions requested, I'm talking about Mensch.
Yes, Your Honor. And so, you know, it was not only not a final order by its terms, but the issue of whether the case was going to be dismissed with prejudice was still a live issue in the trial court. Under the standard that the defendants are proposing, the plaintiff would have been required to come back into court, refile her case within a year while the prior case was still pending and while there was still a live issue about whether the prior case would be dismissed with prejudice. That is the absurd result that should be avoided here, and adopting a rule that is much closer to a final order, final judgment rule is much more consistent with the Tennessee Saving Statute, which, you know, in the text of the Tennessee Saving Statute, it refers to a judgment. So this is not a far-fetched result given the text of the statute and the well-established public policy that the statute should be interpreted liberally and broadly to reach a result on the merits.
What about Rule 41.01, paragraph 3?
Yes, Your Honor. And that was added after some of the authority that we've cited in this case.
Correct.
To make clear that it's not the notice of voluntary dismissal that triggers the running of the saving statute. It's the entry of the order voluntarily dismissing the case. And certainly by the letter of that rule, there was an order entered that said the case is voluntarily dismissed or non-suited. However, it also said this is not a final order, which created the unusual circumstance here. And then the case remained pending in the court with a potential dismissal with prejudice for another 13 months.
In terms of the connection with the saving statute, we also have the advisory commission comment here. The order entry date would start the saving year running under TCA 28-1-105. What's your response in terms of the advisory comment? That seems rather problematic for your position here.
Certainly the rule and the advisory committee comment say what they say, and we don't dispute that. But the statute itself refers to a judgment, and the controlling case law never quite interpreting a situation like this, in which there have been two orders 13 months apart, one explicitly non-final and one adjudicating the dismissal with prejudice question 13 months later. But the statute and the controlling authority certainly apply, notwithstanding the language of the advisory commission comment.
Would you agree that we have to read the statute and the rule together in terms of interpretation?
Certainly, the rule has the force of law and should be read in the context of the statute and of the controlling authority, Your Honor. The court here relied on cases that contain analogous circumstances, but found that there was no case on all fours. And that's why Judge Ingram, when she considered this issue, which she gave it 3 rounds of briefing and 3 hearings before she reached a very considered result, and found that this case was like the Parrish versus Marquis Supreme Court case, which explicitly said, this should not operate as a trap for litigants because the saving statute is remedial and must be liberally construed. The case law on when the date of a notice of appeal should be filed and when the date plaintiff must refile under the saving statute, the case law is intermingled, which suggests to me that this final order rule would behoove us to adopt with respect to the saving statute. However, for purposes of this case, this court does not have to make a bright line rule that applies to all cases in all situations. It just needs to find that in the unusual circumstance presented here, the saving statute would favor waiting until the final order came down before refiling the case.
Well, if we did that, wouldn't we be setting up a scenario where you were preventing someone from asking for a motion for a case to be dismissed with prejudice, because then they set up this scenario where there has to be finality under your analysis?
You mean preventing someone from asking for a case
Yeah.
to be dismissed with prejudice after it had already been non-suited?
Yes. Or asking for sanctions in that way.
I think under that unique circumstance, which is not, I would assume, very common in litigation, the later date makes more sense and is more consistent with the Tennessee savings statute. I don't think that creates an unworkable scenario. And here it was 13 months, which in my view seems like a long time to adjudicate that motion for sanctions to begin with. Normally, I think this would be done fairly quickly.
I think I may have interrupted Judge Usman, but.
Sorry, Judge Usman, did you have a question?
I was curious about your response on the language from Childs in terms of the closing portion there where during the pendency the first action must await for another day. Opposing counsel suggests that Childs is internally inconsistent. What do you make of the language in Childs suggesting that, in fact, they didn't decide this question?
Well, number one, I would never suggest that the Court of Appeals was ever internally inconsistent in its opinions. But more to the point, there is some inconsistency there. We have not chosen to frontally attack Childs because there is language in the case that suggests that serving your pre-suit notice during the pendency of the prior case is ineffective. However, moving to the extraordinary cause piece, Judge Ingram did weigh all those factors, including Childs and Myers, distinguished this case on its facts from those cases, looked at extraordinary cause in Howell and Hinkle, despite recognizing that Myers is the last word on whether substantial compliance is good enough under the Healthcare Liability Act pre-suit notice statute, and it's not, or whether extraordinary cause exists. And what the trial court here found was that extraordinary cause did exist to excuse the noncompliance.
If your position is correct in terms of timing, is the pre-suit notice still premature in this case? And sanctions was sent back to the trial court, at least my understanding in terms of the record of this case, as the time this decision's made, that's still pending. And so are we still premature in terms of the pre-suit notice being submitted in this case?
Under the letter of the Healthcare Liability Act and given the pendency of the prior case, yes, that would be the case. However, the Healthcare Liability Act includes this extraordinary cause exception for situations like this. And the case law includes situations in which a plaintiff did not even provide pre-suit notice before filing their second case. That's not the situation here. And so, in fact, it was pretty well surveyed in Hinkle itself. There was a good survey of the case law looking at the extraordinary cause argument and finding that cases in which someone did provide notice, albeit premature notice or maybe slightly defective notice, those cases tended to support a finding of extraordinary cause. Cases in which the plaintiff just didn't provide notice the second time tend not to find a tend not to support a finding of extraordinary cause. And here there's no dispute, and as the trial court noted, the defendants did not dispute that before filing the second time, more than 60 days before refiling, the plaintiff provided pre-suit notice again, and it complied with the statute, and filed a certificate of good faith when the complaint was refiled. But again, this is a plaintiff in a situation in which there's been an order granting a voluntary dismissal that expressly says it's not a final order, and the motion for dismissal with prejudice is still pending. The plaintiff waited 10 months, served pre-suit notice, and then refiled their action after the previous action was dismissed. This is precisely the kind of a situation that the saving statute and the public policy of Tennessee, as well enshrined in Supreme Court precedent, suggests should not operate to kick a case out of court that has not reached the merits. And one more point on the question of what constitutes extraordinary cause. An issue of first impression may, in some cases, constitute extraordinary cause. That's from the IGU v. Vanderbilt University case in the Court of Appeals in March 2015. We submit that that is the situation here. The two orders threw the case into confusion. There's no standard requiring an evidentiary record. This is the court's discretion to find extraordinary cause, and she appropriately found that here. If anyone has any more questions, I'm happy to answer them, but otherwise, I thank the court for its time.
Did she say that in her order?
That she found extraordinary cause?
No, because of that. Because of the situation you just described.
Yes, my reading of her order is that she recounts and that would be at page 14 of her order to the end. In the technical record, it starts on page 190, but she recites the extraordinary cause standard and then references back to her discussion in the prior section about the two orders here and the confusion that created.
Okay, I read it. I just didn't read it quite as succinctly as you just said it, so
Okay.
I wanted to make sure it was.
Well, I'll defer to your reading of the order over my summary, Your Honor.
Don't do that.
But I do find that the court was very clear and very thorough in considering the extraordinary cause argument and its relation to the unique circumstances of this case. And that's a finding that this court should review under an abuse of discretion standard because that is the standard that the court uses for extraordinary cause review. Thank you.
Thank you.
I want to start where the court just ended. It is an abuse of discretion standard, but it is a mixed question of law and fact. So part of the trial court's rulings on extraordinary cause are not given deference. The plaintiffs just suggested repeatedly this was an unusual pair of orders. Well, the Minch case is precedent that was in place and was not challenged on appeal. In other words, the trial court applied the law in effect at the time when it said this is not a final order. There's nothing confusing about that. The appellants in Salas 1 did not challenge the fact that the trial court appropriately exercised continuing jurisdiction over the sanctions issues. So also the plaintiffs have suggested that there was a live issue of the trial court dismissing the case with prejudice. The trial court had announced in open court long before that sanctions order came down that it was not going to dismiss the case with prejudice. That was not a live issue at the time, but it brings this back to the point I made earlier about extraordinary cause. If the plaintiffs believed that this was still a live issue, why did they send pre-suit notice while that issue was still live? Why didn't they send pre-suit notice after the sanctions order was entered? And I think that's the main problem that the plaintiffs have in demonstrating extraordinary cause in this case. Regardless of which date the court uses for the saving statute, the plaintiff didn't follow the law. So this is not an instance where we can say, well, the plaintiff made a studious study of the law and chose to follow one path versus the other and was wrong in what they chose. The plaintiff didn't follow the law either way. And so that's why they cannot demonstrate extraordinary cause. I believe as Judge Usman mentioned the advisory comment to Rule 41, I just wanted to note the Supreme Court has at least cited or quoted that comment with approval in the Lynn versus Beeman Dodge case. It's not directly on point with these issues, but it certainly lends credibility and credence to the advisory comment to Rule 41, which says the saving statute begins to run on the date of the order of voluntary dismissal. The plaintiffs have suggested that the court doesn't have to adopt a bright line rule in this case with whatever it does. Well, obviously, what the court does will have precedential effect, and the court must consider what are the downstream effects going to be of the court's decision. Or is the court going to create absurd results by adopting a finality rule, which is what we submit would occur. Any argument from the plaintiffs that child should be reversed, we submit is waived because it hasn't been briefed. Plaintiff's counsel just conceded an argument that there was no frontal attack on child, so we submit that argument's been waived. And then lastly, I just want to briefly address Hinkle. The Hinkle case does have a survey of extraordinary cause cases, but it's before Myers. It's before Myers sets the extraordinary cause standard, and the case law in Hinkle, ultimately the court in Hinkle did not reach the issue of extraordinary cause. They expressly state that in the opinion. So for the reasons we've stated, we would ask the court to reverse the trial court and grant our motion to dismiss. Thank you.
Thank you. Thank you both. Would you please call the next case?
Mark Levon Ford versus April Corinne Ford.
Good morning. May I please reserve 3 minutes for rebuttal?
3 minutes, okay?
Thank you. I know that's kind of precise. Good morning. I'm Carla Miller of the Nashville Bar, and I represent April Ford, who's in the courtroom today. She is the mother of 8 lovely children, and this is an appeal from the judgment of the General Sessions Court in Jackson County, Tennessee. The